Diagram 2A is a flow diagram that gives you an overview of contract formation. It asks questions in the order that they would naturally arise in a problem question. The diagram should also help you during revision. The first question is there an offer that can be converted into an agreement by an acceptance, or is there something less than an offer, called a mere invitation to treat, which can't be turned into an agreement by acceptance? The distinction between an offer and an invitation to treat depends on three things. First, the objective test of intention. Here the question is, would the reasonable person interpret the words or conduct in question as manifesting an intention to be bound on the addressee's acceptance? Second, are situation-specific rules, for example, that displays and advertisements are generally only invitations to treat. But note that these rules are all subject to exceptions. Third, are policy considerations such as consumer protection and the avoidance of unfair results that clearly influence how courts interpret the parties' conduct. We can see them in operation in the exceptional cases like Chapelton and Barry, Carlo and Carbolic Smokeball, and the rule that you can't accept by silence. If there's no offer, but just an invitation to treat, there's nothing to accept and so no agreement. You have to look for some other words or conduct that can qualify as an offer. There's an offer if there's a manifestation of willingness to be legally bound by the terms of the offer as soon as it's accepted by the person to whom it's addressed. It may be important to decide whether the offer is unilateral or bilateral, because different rules apply on whether the offer can be revoked, on how the offer is accepted, and how the acceptance is communicated. A unilateral offer stipulates a promise for an act. It's accepted by completed performance of the stipulated act, even if the offeror doesn't yet know of it. So communication of the fact of completion is not required for the contract to be made, though of course the offeree must let the offeror know when she tries to enforce the contract. The other point to note is that while an offer can normally be revoked any time before acceptance, a unilateral offer can't normally be revoked once the offeree has commenced performance. This protects the offeree's reliance, but again there are exceptions. In contrast, a bilateral offer stipulates a promise for a reciprocal promise, and it becomes binding as soon as the reciprocal promise, or we call that the acceptance, is given. This is so even before anyone has started performing, let alone completed its performance. For the reciprocal promise to be a valid acceptance, it must, first, correspond with the offer. In theory, this is all or nothing. There can't be any deviation from the terms of the offer. If there is a deviation, this may be interpreted as a counteroffer, and this kills the original offer, which then can't subsequently be accepted. This is where the battle of forms issue is located. Second, a valid acceptance must be in response to the offer so that matching cross offers don't amount to a contract. Third, a valid acceptance must be made in an appropriate way, for example, as stipulated in the offer or as is reasonable. If any of these conditions are not met, there is no valid acceptance and so no contract. If there is a valid acceptance, we still have to fix the time of acceptance. This is important because it's the time when the contract was made and the door is closed. Neither party can thereafter change the terms or get out of the contract. The answer to the timing question depends on how the acceptance was communicated. If the offeree sent the acceptance by post, then the question is whether the postal acceptance rule applies. If it does apply, then acceptance takes effect when the letter is sent. After that point, the offeror can't validly revoke her offer although she has yet to receive the letter of acceptance, and the offeree can't validly withdraw his acceptance even if he uses a quicker method, like phoning the offeror before his own letter arrives. The postal acceptance rule doesn't apply just because post is used. It may not apply if it's unreasonable in the circumstances, or if it prejudices the offeror, or if the offeror says that she must actually receive or know of the acceptance. In these cases, acceptance takes effect when the letter is actually received by the offeror. Note that the offeror is expected to behave reasonably. She shouldn't just throw the letter away or give it to the dog. She should act reasonably, open and read it. In contrast to the post, if the offeree uses an instantaneous method of communicating his acceptance, then it takes effect when and where the offeror receives the message. In Brinkebon and Starhag-Stahl, Lord Wilberforce explained that this was because the condition of simultaneity is met. For example, with telephone or face-to-face conversation, communication is two-way instantaneous. Both parties are present, and it's reasonably obvious whether the message has got through or not, and it's relatively easy to remedy any problems. But what if the condition of simultaneity is not met? Where communication is only one-way instantaneous, like answer phone, email, or text. An acceptance by these methods can arrive almost instantaneously, but the offeror recipient is not necessarily at the other end ready to receive the message. The problem arises when either party tries to withdraw before the message is actually accessed. This is the common scenario for exam PQs. For example, with email there are 5 possible points of acceptance, and there are no cases stating which one is correct. So you will have to reason these out. First, when it's sent, by analogy with the postal rule. Given the controversy over the postal rule, perhaps this is not the ideal rule. Second, when the email arrives on the offeror's server. This is certain, but it may not be accessible to the offeror due to the spam filter or firewall setting. So the third option is when the email is accessible. Having got through the spam filter or firewall, the problem is that the email may be accessible but not accessed. And therefore, the fourth option is that the email arrives when it's reasonably accessible by the offeror. Whether an email is reasonably accessible depends on the time it arrives in the inbox. For example, if it's 3 a.m., it might not be reasonable to expect that the offeror will check at that time. It may also depend on the particular email account the message was sent to. Was it one that the offeror is known to use and check? And would it also depend on any automatic response email, for example, saying that I'm trekking the Himalayas and I won't have email access for 3 days? Fifth, the email should not be construed as having been communicated only when it's read by the offeror. That would allow the offeror to behave unreasonably by not opening or reading the email. Once we've fixed the time for acceptance, the question arises as to whether the offer was still live at that time to be accepted. The offer can be terminated by the offeror's revocation, or the offeree's rejection or counteroffer, or the lapse of the offer through the expiry of the stipulated or otherwise reasonable period of time, or the death of either the offeror or the offeree. If the offer is validly terminated, then the purported acceptance is invalid and there is no contract. If the offer remains alive at the time of acceptance, then you have a valid agreement. But a fully enforceable contract must satisfy 3 other requirements. First, it must be sufficiently certain. In practice, the question is whether any uncertainty or incompleteness is curable by the courts. The courts can cure by reference to the party's previous dealing, or the custom of the relevant trade, or the standard of reasonableness, or by the court substituting its own mechanism for the defunct but non-essential mechanism stipulated by the parties. The second additional requirement is called intention to create legal relations. Of course, you already need a serious intention to be bound to find a valid offer and a valid acceptance in the first place. What the requirement really means here is that the agreement must be one that the courts regard as appropriate for it to support by putting the weight of the law behind its enforcement. As a general rule of thumb, courts will enforce commercial agreements unless the parties very clearly stipulate otherwise. And courts will generally not enforce agreements made in a family or social context, unless it's really commercial in nature and the parties' relationship is merely incidental, or the agreement is made to end the parties' relationship, as when you make an agreement on the breakup of the marriage. Thirdly, the agreement must satisfy one of the requirements of enforceability. The most common one is the requirement called consideration. An agreement will only be enforceable if each party has given the other something that the other values as part of a bargain. Exceptionally, an agreement may be enforceable without consideration because it has satisfied formality requirements, as where it's made in the form of a deed. And lastly, the court may enforce a promise where the promisee has reasonably relied on the promise to her prejudice. This is the doctrine of promissory estoppel.